everyone, welcome to iExamBee. So we'll be continuing ahead with our mock test series discussion in this particular video also, and the subject I'll be discussing on is the insolvency and bankruptcy code. But before that, do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. आप हमें इस email ID के थ्रू कांटेक्ट कर सकते हो या आप हमें कॉल भी कर सकते हो इस नंबर पे अगर आपको कोई भी क्वेरीज हो। इसके अलावा आप हमारी वेबसाइट को भी विजिट करो जहाँ पे कि आपको डिटेल्ड इन्फॉर्मेशन मिल जाएगा with respect to various competitive exams. As I already mentioned you that today I'll be discussing the various MCQs with respect to insolvency and bankruptcy code, और उसके अंदर जो आज हमारा टॉपिक ऑफ डिस्कशन है MCQs में वो है adjudicating authority for the corporate persons. So we'll be looking on to the different aspects related to the adjudicating authority for the corporate persons under the code. And so to begin with, our very first question is, under the IBC, the adjudicating authority in relation to the insolvency resolution and liquidation for corporate persons including corporate debtors and personal guarantors shall be the. So who will be the adjudicating authority with respect to insolvency and liquidation of corporate persons? Options are DRT, Company Law Tribunal, National Company Law Tribunal, National Company Law Appellate Tribunal, and none of the above. And the correct option for this particular question is C, which is National Company Law Tribunal. So National Company Law Tribunal जो है adjudicating authority है as per section 60 of the code with respect to the insolvency resolution and liquidation for the corporate persons, which is having the territorial jurisdiction over the place where the registered office of that particular corporate person is located. Now next question is, as per the provisions laid down under the code, every appeal shall be filed within dash days before the National Company Law Appellate Tribunal. Various options are 14 days, 30 days, 60 days, 45 days and 90 days, and the correct option is 30 days. So option B हमारा यहाँ correct है जो कि section 61 में provided है, which talks about appeals and appellate authority. Every appeal be filed within 30 days before the National Company Law Appellate Tribunal. The appellate authority may allow an appeal to be filed after the expiry of that particular period if there are sufficient causes for non-filing and all. However, the period cannot exceed 15 days. Now the third question is, IBC provides that the Supreme Court, if it is satisfied that the person was prevented by sufficient cause from filing an appeal within 45 days, allow the appeal to be filed within a further period of, and the correct option for this is C, which is not exceeding 15 days. So section 62 is providing the provision that appeal to the Supreme Court. Supreme Court may, if it is satisfied that a person was prevented by sufficient cause from filing an appeal within 45 days, allow the appeal to be filed within a further period not exceeding 15 days. So 15 days is the extension period. The next question is, as per the provisions of the code, an appeal to the Supreme Court may be filed by any person aggrieved by an order of the National Company Law Appellate Tribunal within 45 days from the date of receipt of such order, on a question of law arising out of such order within 45 days from the date of receipt of such order, on a question of fact arising out of such order within 45 days from the date of receipt of such order, either A or B or C, either B or C. And इसका correct option है option B, which is on a question of law arising out of such order within 45 days from the receipt of such order. Section 62 is providing for this provision that any person aggrieved by an order of the National Company Law Appellate Tribunal may file an appeal to the Supreme Court on a question of law arising out of such order under the code within 45 days from the date of receipt of such order. Now the question number 5 is, the National Company Law Appellate Tribunal may allow an appeal to be filed after the expiry of the period of 30 days if it is satisfied that there was sufficient cause for not filing the appeal, but the period shall. So as per this particular question, the National Company Law Appellate Tribunal can also provide an extension with respect to filing of an appeal before it. However, that extension cannot exceed what time period or what duration, and इसका correct option है A, not exceeding 15 days, जो कि हमारा section 61 में provided है. Appeals and appellate authority में every appeal shall be filed within 30 days before the National Company Law Appellate Tribunal, provided the appellate tribunal may allow an appeal to be filed after the expiry of the said period if there was a sufficient cause for non-filing the appeal, but the period shall not exceed 15 days. Question number 6 is, where an application is not disposed of within the period specified under the code, the National Company Law Tribunal or the National Company Law Appellate Tribunal shall extend the period specified in the code exceeding 10 days, exceeding 30 days, not exceeding 10 days, not exceeding 15 days, not exceeding 45 days. So these are the various options which are available for this particular question, और इसका सही आंसर है C, not exceeding 10 days. तो सेक्शन 64 बोलता है expeditious disposal of application, जहाँ पे की प्रोविजन है कि when an application is not disposed of or an order is not passed within the period specified in the code, the National Company Law Tribunal or the National Company Law Appellate Tribunal, as the case may be, record the reasons for not doing so within the period specified, and the President of the National Company Law Tribunal or the Chairperson of NCLAT may, after taking into account the reasons so recorded, extend the period specified, not exceeding 10 days. Then the next question is, as per the code, any person aggrieved by an order of the National Company Law Appellate Tribunal may file an appeal to whom? And the correct option is Supreme Court, which is option B. So section 62 again इसके बारे में provision provide करता है कि any person aggrieved by an order of the National Company Law Appellate Tribunal may file an appeal to the Supreme Court on a question of law arising out of such order within 45 days from the date of such order, and if the Supreme Court is satisfied that there was sufficient cause for non-filing an appeal within 45 days, it may provide a further period not exceeding 15 days. So all these aspects related to making an appeal to the authorities, the time period duration within which it has to be made, or the extension period which can be provided, all these are very important if we talk about the adjudicating authorities for the court person. Now question number 8 that talks about who are the persons who are not entitled to make an application to initiate the corporate insolvency resolution process. तो हमने CIRP देखा कि वो process क्या है and all. CIRP में there are categories of people who can go ahead and initiate and make an application to the authority. Along with that, there are provisions also under the code where it mentions that there are certain persons who are not entitled to make an application for initiating this particular process. So this question is related to that, and the correct option for this is E, either of the above. So either of these are not basically entitled that they can go ahead and make an application for initiating the process. Section 11 इसके बारे में provision provide कर रहा है persons not entitled to make an application. So who are those persons? Corporate debtor undergoing the corporate insolvency resolution process or pre-packed insolvency resolution process, financial creditor or operational creditor of corporate debtor undergoing pre-packed insolvency resolution process, corporate debtor having completed CIRP 12 months preceding the date of making of application, corporate debtor in respect of whom a resolution plan has been approved under Chapter 3A 12 months preceding the date of making an application, corporate debtor or financial creditor who has violated any of the terms of the resolution plan which was approved 12 months before the date of making an application, or a corporate debtor in respect of whom a liquidation order has been made. So all these category of persons, they cannot go ahead and make an application for initiating CIRP. Then question number 9 talks about the central government specified dash as the minimum amount of default for the matters relating to PPIRP of the corporate debtor. So in the code, the limit has been provided with respect to CIRP and PPIRP both, and the central government has specified that limit, which will be the minimum amount of default with respect to the matters related to either of the process. So with respect to PPIRP, the correct option is B, 10 lakh rupees. Okay, so 10 lakh is the minimum amount of default for the matters relating to PPIRP. Section 4 is talking about that. Central government may by notification specify such minimum amount of default or higher value which shall not be more than 1 crore rupees for matters relating to PPIRP of the corporate debtor. Central government specified 10 lakh rupees as the minimum amount of default for the matters relating to PPIRP of the corporate debtor. So 10 lakh is threshold limit. And the last question for today is, how many legislations have been amended by the code? When IBC came into existence, there were various legislations which were amended. So this question is talking about the number of legislations which were amended when the IBC came into existence, and the correct option is 11. So IBC led to the amendment of 11 legislations, and they were the Partnership Act, the Essential Excise Act, the Income Tax Act, the Customs Act, the Recovery of Debts Due to Banks and Financial Institutions Act, Finance Act, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests, the SIC Industrial Company Special Provisions Repeal Act, Payment and Settlement Systems Act, Limited Liability Partnership Act, and the Companies Act. So this is the list of those acts or legislations which were amended when the code came into existence. And so with this, we come to an end to our discussion. Do remember to subscribe to our channel and stay tuned for various such videos.